Mr. Speaker. I think we need to start with why parliamentary privilege is so important, particularly those of us on the government side, because there will come a time when we are not on the government side, at which point the protections provided for us by parliamentary privilege are all the more important, and that governments who run roughshod over parliamentary privilege when they are in government find that when they are in opposition, their position is much harder to defend and uphold. When the Conservatives were in opposition, we disliked the streamlining of parliamentary procedures that made it easier for the then government to get legislation through, because we found it harder to have the full debates, the full discussion that we wanted, the ability to discuss and sometimes even delay things which we were deeply opposed to. And that was a loss to us in opposition, even though a benefit once we were back in government. And my right honourable friend, the Lord President of the Council, mocked the humble address procedure on the basis that it was ancient. But every morning when we come into this House, when we pass through security, we are exercising a right that dates back to 1340. Whether you have your pass on you or not, you are entitled to come into this House, and nobody is entitled to obstruct you. And this is an important right because in times less benign than ours, people have wanted to obstruct members coming into Parliament. And we sit in a House where there is a very slim margin. And it may be that rushing back for a division, perhaps a division of confidence in the government, somebody obstructs you coming in, but that would be a breach of your privilege, and though it is very ancient, one of our most ancient privileges, it is actually a great safeguard of the proper democratic operation of this House. And we heard from the Treasury bench and from other right honourable members a very good argument for why the humble address should not have been passed in the first place. But today is the wrong day for that debate. That debate should have been held on the 13th of November and voted on or not, according to whether or not it were the will of this House for the humble address to go through. And the tradition of humble addresses is very clear, that the humble address is followed. Now, that does not mean that this House is irresponsible in passing humble addresses. We have heard suggestions that we might seek information from the security services. This House has never passed a humble address of such an unwise kind. And though I am not, dare I say, the greatest admirer of the socialists opposite, I accept that they are responsible enough not to wish to endanger the security of our nation. But that Parliament has the power does not mean that Parliament will exercise the power. Indeed, and importantly, this House constrains its right of free speech in relation to the sub judice issue. We have passed standing orders, and we give power to Mr. Speaker to stop honourable and right honourable members breaching the sub judice rule to ensure that the system of justice in this country proceeds properly. Likewise, we are entitled to limit the means of humble addresses and the information that can be received from a humble address. But we did not do so before the 13th of November. And therefore, what happened on the 13th of November ought to be complied with. Because if we simply say that motions of this House, according to great antiquity and precedent, can be ignored because the government feels like it, then what is this House here for? How are we protecting the rights of the people we represent? How are we able to seek redress of grievance? And the fact that it might have been unwise, indeed, had there been a division on the 13th of November, I would have voted against revealing the Attorney General's information and advice to the government. I did not think the humble address was well advised, but the government decided to accept the motion. And having done so, it was not then up to the government to say that it was not in the national interest to do so. I'm afraid that is a classic confusion The government interest and the national interest are different things. The government interest is a political interest. The national interest is a higher interest. And in my view, the national interest is better served by respecting the privileges of Parliament than the convenience of the law officers. And therefore, in the national interest, not the government interest, this legal advice ought to be produced because Parliament has said so. And this is clearly a right that this House has. Every select committee has the delegated right to send for persons and papers. And this is simply an exercise by the whole House of requiring that papers be produced. But the government with its majority, perhaps a majority it cannot always achieve, but at least with a technical majority, thanks to our friends in the Democratic Unionist Party, the government with its majority ought to be able to stop any papers it believes too confidential from not being produced. And indeed, it is still open to the government to bring forward a motion suggesting that the previous motion be overturned, and there is precedent for overturning an humble address and seeking to do the opposite. So there is a proper process for the government to follow if it does not want to release these papers, rather than sticking its feet in the mud and saying no. So then we come to the motions before us today. And here I agree with my right honourable and learned friend, the member for Beaconsfield, that I don't think the motion before us actually works, because it is too indistinct about who it is criticising, that it is criticising ministers broadly rather than the ones specifically concerned. And I think the motion needed to be more specific on who it was objecting to, who it was holding in contempt, and indeed ought to have used the rights that Parliament had to inflict some punishment on the person who is deemed to be in contempt. Yes, of course, I give way.
I'm grateful to the honourable member for giving way. If he feels as he has described, why didn't he put down an amendment to my right honourable friend's motion, setting out the position as he thinks it ought to have been done?
Well, I'm very grateful to the right honourable lady for her intervention, because the government has put forward an amendment that I feel that I can support, though we're not the pantomime season quite yet. All right, I give in on that one, Mr. Speaker. I am defeated on that particular point, but not on the substantive one. That I am happy to support the government's amendment, because I think it is right that a committee of this House looks at the issue in broad terms, because it may be right that the House wishes to take a self-denying ordinance on the extent of humble addresses. It may be that we would like to say specifically that they would be deemed disorderly and therefore not brought forward if they related to matters concerning the security services or other types of information where there would be a broad consensus that those matters should not be brought forward. Dare I say, the ability to demand papers could require that the tax return of honourable gentlemen and ladies opposite be brought forward to the House. Mine would be of so little interest I can't imagine it happening. But that would be a clear abuse. That would be a clear abuse of the precedents that we have. So it may well be right that the Privileges Committee should consider broadly how humble addresses should be used to ensure that they are effective, because currently they ought to be effective. The government ought to abide by them. But there is one... Yes, of course, I'll give way.
As ever, following his remarks with a great deal of interest, he will know, since he's an expert on Erskine May, that at page 168 from memory, it says very clearly that the humble address should not normally be used on matters that touch directly on bills before Parliament, as this clearly does. So was the humble address being used correctly in his view or incorrectly?
I'm sorry to say that my honourable friend isn't quite right. There is not a bill before Parliament on this issue. There is a motion before Parliament on this issue, and those two are clear separate matters, that they are not to be confused. And I have no doubt, Mr. Speaker, that had an humble address been brought forward on a bill before Parliament, it would have been ruled disorderly and therefore would not have been a subject for debate. And for the benefit of the Hansard reporters, Mr. Speaker is nodding, and therefore I hope this can go into the record as an authoritative reply. There is one concern I have about the reference to the Privileges Committee, and that is, of course, that the Attorney-General is himself a member of that committee, though a non-voting and a non-adding to quorum member of it. And I'll give way to my right honourable friend.
Officers would recuse themselves from any such meeting.
Well, I'm extremely grateful because
just speak into the microphone. The vast majority of members haven't got the slightest idea what she was saying.
I'm sincerely sorry, Mr. Speaker. The law officers would recuse themselves from any such meeting.
I'm extremely grateful for that. That gives me complete confidence in supporting the government's amendment. But I would absolutely reiterate that however the vote goes today, the humble address must be obeyed unless overturned, and for the government to fail to do so would not be treating Parliament properly. And on these benches, we must remember the great need for us, when we are in power, to defend the rights of Parliament for those occasions when we will not be.